Okay, you're welcome to resume the board meeting.
Thanks, Tessie. It's 11:51 a.m. The board is out of executive session. Let's turn to the matter of the remand of Michael Garber, MD. On November 9th, 2016, the medical board issued a notice of opportunity for hearing to Dr. Garber based on his alleged failure to submit to a board-ordered examination for chemical dependency and his alleged failure to notify the board of any circumstances beyond his control preventing him from submitting to the examination. The board further alleged that as a result, a legal presumption had been established pursuant to Ohio Revised Code Section 4731.22b26, and that he had admitted the factual and legal allegations set forth by the board in an August 18, 2016 letter, thus demonstrating impairment of his ability to practice according to acceptable and prevailing standards of care because of habitual or excessive use or abuse of drugs, alcohol, or other substances that impair ability to practice. On July 12, 2017, the board issued an order which suspended Dr. Garber's license to practice medicine and surgery and then stayed the suspension. Dr. Garber timely filed an appeal of the board's order with the Franklin County Court of Common Pleas, which affirmed the board's order on August 21, 2019. Dr. Garber timely filed an appeal with the Court of Appeals, 10th Appellate District, which issued an order on May 12, 2020, reversing the judgment of the Franklin County Court of Common Pleas and remanding the case to that court with instructions to vacate the medical board's July 12, 2017 order and to remand the matter to the board for further proceedings in accordance with its decision. Specifically, the court determined that the board never afforded Dr. Garber the opportunity to be heard as to whether the order to submit to a 3-day examination was supported by a reason to believe that his ability to practice was impaired by the habitual or excessive use of drugs. The court held that the board did not act in accordance with law when it imposed the stayed license suspension without affording Dr. Garber the opportunity to be heard on and without determining the threshold question of whether the board had reason to believe that his ability to practice medicine was impaired due to habitual or excessive use of drugs at the time the 3-day examination was ordered. In this remanded matter, the board has the following available options. Number 1, remand the matter to the hearing unit for the purposes of reviewing proffered evidence and or additional evidence from the state, including testimony to assess whether the decision to order Dr. Garber to the examination was based on a reason to believe that Dr. Garber's ability to practice medicine and surgery was impaired due to habitual or excessive use of drugs. Or number 2, dismiss the notice of opportunity for hearing. I will now entertain discussion of the remanded matter of Dr. Garber. Is there discussion? Mr. Jacquelin?
Yeah, I would move that we dismiss the notice of opportunity for hearing. I don't know if we need to go through this process again on remand. I think that would be my proposal, my motion.
Thank you. Is there a second?
I'll second.
Mr. Gonococcus, thank you. Is there further discussion? Okay, hearing none, we'll have a roll call vote on the motion to dismiss the matter of Dr. Garber. Roll call, please. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Jacquelin?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Carolla?
Yes.
Mr. Gonococcus?
Yes.
Ms. Montgomery? Ms. Montgomery? I think Ms. Montgomery said yes. Dr. Fievel?
Yes.
Dr. Bechdel?
Abstain.
And myself, Michael Schottenstein, yes. We'll turn to settlement agreements, please. Do I hear a motion to ratify the proposed permanent surrender with MRP-RCP? Motion?
So moved, Dr. Bechdel.
Thank you.
Dr. Carolla.
Dr. Carolla, thank you. Roll call, please. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Jacquelin?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Carolla?
Yes.
Mr. Gonococcus?
Yes.
Ms. Montgomery?
Yes.
Dr. Fievel?
Yes.
Dr. Bechdel?
Yes.
And myself, Michael Schottenstein, yes. Do I hear a motion to ratify the proposed permanent surrender with JFLMT? Motion?
So moved, Dr. Johnson.
Second, Dr. Bechdel.
Dr. Bechdel, thanks so much. Roll call, please. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Jacquelin?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Carolla?
Yes.
Mr. Gonococcus?
Yes.
Ms. Montgomery,
Yes.
Dr. Fievel,
Yes.
Dr. Bechdel,
Yes.
and myself, Michael Schottenstein, yes. Do I hear a motion to ratify the proposed consent agreement with DMELMT?
Dr. Bechdel, so moved.
Thank you, and
Dr. Johnson, second.
thanks very much. Roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Jiggle,
Yes.
Dr. Stane.
Yes.
Dr. Johnson,
Yes.
Dr. Carolla,
Yes.
Mr. Gonococcus,
Yes.
Ms. Montgomery,
Yes.
Dr. Fievel,
Yes.
Dr. Bechdel,
Yes.
and myself, Michael Schottenstein, yes. Do I hear a motion to ratify the proposed consent agreement with AKELMT? Motion?
So moved, Dr. Johnson.
Dr. Johnson, thank you, and
Second, Dr. Carolla.
thank you so much. Roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Jacqueline,
Yes.
Dr. Stone,
Yes.
Dr. Johnson,
Yes.
Dr. Carolla,
Yes.
Mr. Gonococcus,
Yes.
Ms. Montgomery,
Yes.
Dr. Fievel,
Yes.
Dr. Bechdel,
Abstain.
and myself, Michael Schottenstein, yes. We'll turn now to notices of opportunity for hearing, orders of summary suspensions, orders of immediate suspension, and orders of automatic suspension. Ms. Marshall, Chief Enforcement Attorney, will now present the proposed citations to the board, please.
Just one moment, please, while we get Rebecca logged back in.
Yeah, of course.
Hi, Rebecca.
Hi, Rebecca.
All right. Dr. Schottenstein, can you please repeat your last line, and then we'll have Rebecca join us.
Of course. Ms. Marshall, Chief Enforcement Attorney, will now present the proposed citations to the board.
Thank you. Sorry, I was having some trouble getting back in.
Yes.
We have 8 citations for you today. The first is to be issued to a DO with a training certificate. It's an applicant who disclosed that he had entered into a guilty plea to assault on a female in North Carolina in 2012, which is a misdemeanor of moral turpitude and an alleged lack of good moral character. Any questions on this? Our second cite for you, and I noticed in onboard, cites 2 and 3 are reversed. So cite number 2 is issued to an MD who lives in California. It is based on actions taken by the Washington Medical Board. This did have a typo in it. If you notice that, it said on or about September 2020, they took an action. That obviously hasn't happened yet. That was actually January, and we have corrected that in the notice that will be mailed out. Any questions on this? Right. Site number 3 is to be issued to an MD. It's based on actions by the Georgia Medical Board, based on a guilty plea to reckless conduct involving the patient. This person's Ohio license has lapsed, and that's why this is not a summary suspension. Any questions on this? Site number 4 is to be issued to an MD. This particular position was previously cited by you in April of 2019 for temporary suspension actions in other states. That matter is still pending for hearing. This site is based on the denial of license by Utah and the final decision by the Massachusetts board that issued a revocation and blocked him from practicing there for at least 3 years. Questions?
I have a question. Is he currently licensed in Ohio, and where is he practicing now?
His address is in Massachusetts, so he's not practicing here now. I do not know about his license status here.
So this is where I struggle again about these idea of summary suspension. Again, this person has been banned from practicing in many states and yet has a license here. This will take a year to adjudicate this. And anyhow, it's just something we need to, I think, continue to investigate these summary suspensions versus not.
Yes, I understand that. One of the things the secretary and supervising member will look at when they're making the decision of whether or not they can meet those legal prongs for the immediate and serious harm to Ohio patients is how close they are in proximity to Ohio. So here, Massachusetts is not really close to us, and we don't have any information that he is actively practicing. But if we got that and they felt it was warranted, they could always do a summary suspension based on that change of circumstance if they felt it was necessary. Anything else? Okay. Citation number 5 is to be issued to a massage therapist. It is an alleged sexual misconduct involving 3 patients.
I have a question on this one.
Yes.
Mr. Chairman, Rebecca, in this, forgive my ignorance here. Here we have an allegation of a boundaries case, and it sounds like a serious boundaries case. And as a massage therapist, and query, is he practicing now? Do we have summary suspension abilities for massage therapists? And if so, don't you think this is one that would require that rather than a citation?
So I'll answer your last question first. It's not my decision about a summary suspension. That's always in the discretion of the secretary and supervising member in consultation with us and the AGs about those legal thresholds that you have to meet. So that is always in their discretion. You do have 3 allegations here, although one of them is from 2017. 2 of them are from last year, 2019, so they're now several months old. If we had more current information of any violations, that would be in the site. This person does have an active license.
So I guess the question I would ask would it go to Kim then? Is that what you're suggesting? I mean, what I don't understand is I don't think what we have is at this point looks like a pattern and practice of a predator. Now, again, that I just superficially what we're looking at. And I don't think that it's a 2 or 3 years old just tells me that this is an ongoing issue. And so I guess the question would be, I have concerns, say he has a license now.
Correct.
Because I would do more than cite if we have something more serious process that we could go through rather than just a citation.
Yeah. So I understand what you're saying. I understand how you have that feeling looking at the site. What I think I can share with you is the secretary and supervising member and the entire staff is very focused on sexual misconduct. Over the past year, we're looking at these and being as aggressive as possible. Remember that the secretary and supervising member have background information that will come to you through the hearing process that we cannot give to you at this juncture. But one of the things they will always look at in these cases is not just what the allegation. Not all victims will testify. So the weight and the credibility of the evidence you have may not always be as strong as you think it might be, and they will always weigh that into their decision making about whether or not they feel they can go forward with a summary suspension. What I can assure you of is that in every sexual misconduct case that we are doing now, we are being as aggressive as we feel the law will support to make sure that we win our case and don't get overturned.
I guess my question again, and I don't know that you can disclose if they're different victims, different name, different folks. And on these, defending I would much rather lose a summary suspension aggressively saying we've got a boundaries issue, we can always fall back on a citation as opposed to missing it. I guess that's my point of view if we see a pattern. I'm not as worried about whether, personally as a former prosecutor, a lot of these things sort of find their way before you get to having to prove it in a courtroom. And it just seems to me protecting, again, not I don't have the information that you folks have, but I don't worry about, well, look, we're not quite sure we're beyond a reasonable doubt. We're not quite sure we read, as opposed to what's happening if this guy is still out doing massage therapy. So I think you fall on the side of not worrying as much about can you prove it if you have a fallback of being able to take other penalties if you can't prove it. These things.
Remember remember your legal threshold here for the secretary and supervising member is that you must have clear and convincing evidence and immediate and serious risk of harm. And we only get one chance. If you do a summary suspension and you lose, you don't get to go back and do it over. So those are things they're also looking at. But I understand your concern.
Refile under a citation?
No, you do not. You only get one chance.
Statutorily, you cannot go back and
right. You only get to notice them on their conduct one time in one way. That's it. You don't get to go back for a second bite.
Okay.
Dr. Fievel.
Yeah, I struggle with this too, and this is one of the problems with, I think, our process is that 10 of us on the board are in the dark and making really serious decisions. I respect our secretary and supervising member, so this is in no way a comment on them, but we're relying as a board on two people making a decision on behalf of the board in these really serious issues. On paper, it sure looks like it's a pattern of behavior and that this person's going to be allowed, based on how we're doing things, that this person is a serious threat. So I think that threshold is met in my mind. They've had 3 different occasions over the course of 3 years, and assuming they're 3 different people, that to me is hard to find 3 people that are making up things about somebody. So the serious threat part is met. The threshold I have trouble with is the clear and convincing evidence, because we don't see it, but we as a board are putting all of our eggs, so to speak, in the basket of 2 people to make that decision on our behalf. And it just brings up, is there, down the road, again, are there different ways we can do this to protect the public? We're in the dark, so I don't know how to handle this. Maybe, Kim, you can help us with how we're supposed to adjudicate this. Because what I'm being basically told is we need to just accept this and move on, is what I'm hearing.
I think, guess, Dr. Fievel, it seems to me that this is probably right for a conversation about process. Not taking away anything from our 2 mute members, because they are not alone making those decisions. They're following the recommendation. Rebecca's people and the folks in the legal end are looking at, it's not just unilateral. When they do their rounds, they're fully informed by other lawyers. But to your question, I think it's, and I too have spoken to Stephanie about, is there some way where we can give us, to be sure that we're doing our fiduciary responsibility, a double check, at least on some of these egregious cases, that would appear to be egregious cases. So I guess I would only say to Stephanie, I hope that we put that on the table for a discussion in certain terms of process after we get the audits from FSMB, SSFMB.
Yeah, I anticipate we're going to have discussions like that. And I guess the thing that I was wondering about as well is, with these cases that look so egregious that are not summarily suspended, is there more than simply no, right? In other words, it's it's an understandable thought that is going to come up as to why this was not summary suspended. So is there more that we can know ahead of time? More that can be put into the memo as to, why that road was not, taken.
Yeah, so there isn't a memo with citations. These are just notices of charges. It's not a settlement. You are going to have this case come in front of you with the full scope of evidence, and you will be able to make a board decision on it. So remember, what you're doing at this point is just issuing the charges. You're not taking a discipline. If the board decides that this person shouldn't have a license, that's going to be your decision when they come. Certainly, again, we always have that immediacy prong, which is usually the more difficult prong for us to get over. If we got, in theory, a new complaint that came in of some new violation, that could bring the immediacy you want to trigger a summary suspension and then have those sites consolidated. But we do legally, with the AGs, go over those two prongs every time there is a serious case and make a decision whether or not you can meet that clear and convincing evidence threshold and the immediacy threshold.
So again, I think the immediacy threshold in the way complaints occur and the way medical board processes work has been met. So the fact that we would get another complaint, this complaint was October 2019, so 6 months ago. The fact that we would get another complaint in June of 2020, to me, it's no more immediate than, I guess it's more immediate, but it doesn't satisfy the immediacy any more than the October 22nd, 2019 complaint. So if that's what we're relying on is the immediacy thing prong, I think we should summarily suspend this person. And I have no way of knowing what we're relying on because I'm in the dark. And so I'm making a vote in the dark, which I don't particularly like doing. So again, I agree with Betty that we need to really, really, really address this issue, especially in light of the Strauss situation and everything else going on.
Rebecca, you're saying, number one, that this person is no longer licensed?
No, I did not say that. He is licensed.
Okay, so they still have a license, so they still can be doing massage therapy.
Correct.
And two, have these been referred to local law enforcement?
Yes. Okay, ready to move on? Oh, Mr. Jackson, I see your hand.
I'm just trying to understand immediacy because this is late 2019. We're in the middle of 2020, less than a year, right? We're about 8 months. What is the cutoff for immediacy? And also my second question is, okay, we have the site in June. This event, the most latest ones occurred in October. When were we notified?
I don't know when we were notified on these.
Doesn't that play a role in the immediacy? We're issuing this in June. If we got it in December of last year, doesn't that meet the immediacy criteria? Or am I missing something? It's when we have to. So, if we drag our feet, something egregious could become basically a non-event.
Yeah, well, we don't drag our feet.
No, let me rephrase that. Okay, there's a lot of
I don't know when we got these particular allegations. It's not unusual for us to get allegations well after the fact. So that is always something. Immediacy is not a black and white issue. It really is kind of, if you think about, putting things on a scale, and it really depends on whether you have 100 little pebbles or 2 giant boulders. When you can meet those threshold requirements is more than just a matter of time. It's time, it's the quality of your evidence, it's the number of things that you have. So we always look at those. And again, we are being as aggressive as we can, but we do only get one shot at it, and it's important to get it right. And
so, Rebecca, one of the things that with all due respect to Stephanie, these are the kind of things that we probably should have a timeline on. And frankly, in the citation, we should know when and you should know when you're reciting to us when we got it. It helps us make some decisions as to immediacy and also as to process, and where there are issues that exist that we need to look at as a board. So I guess my request, Mr. Chairman, and to Stephanie, as well as to you, Rebecca, is give us a timeline and tell us when we got it. And so you can tell us, so we know we make our judgment as to immediacy. If he's still practicing, and it just, and again, not taking anything away from Bruce or Kim, because they are not making a decision in a vacuum. And you are properly worrying about weighing the evidence and not in getting one bite of the apple. So it just is a matter of allowing us to make our fiduciary responsibility a real, living responsibility that we can fulfill.
Yeah, so it sort of gets back to the point I was trying to make earlier, which is there ever a time we can get like a memo that accompanies the citation, right? And is there more information we can have, in matters of this nature that look, on the surface of it so glaring, but maybe there's other circumstances that would, cause us to feel differently about it and help us understand better.
So we'll have to talk to the AGs about that. The challenge is not that we don't want to give you information. The challenge is this is a notice of charges, and in order for the adjudication to be fair and give people due process and hold up when they appeal, we have to not, as enforcement, as the administrative prosecutors, we have to not taint you by giving you information that we know that may not be admissible at the hearing or might not be proper for you to hear in making your decision. It's a burden on us to prove our case at the hearing, and that's the correct burden we should have. So our challenge for you at this point when you're issuing charges is we're trying to give you a fully developed charge so you understand what the picture is and why we're seeking to discipline someone, but we have to make sure we're not tainting things by giving you our unilateral viewpoint of things without the other people getting a chance to put
Well, at the very least, I think we need a time frame. At the very least, that is not going to be a problem with any court. That is not too much information that'll make any difference I don't think in any court saying that we've tainted the finder of fact or the adjudicator. But it's still, this is really troubling. This one is really troubling.
And I don't mean to bog down. Sorry. Go ahead. Keep going.
You're just voting to issue the cite. The determination of those two prongs in your current statutory scheme belongs to the secretary and supervising member, and your balance of checks and balances in that system is you as the board members elect your supervisor and member and your secretary. So I think your secretary and supervising member are great. If the board ever decided they were unhappy with that, they could elect new people. That's your checks and balance. But you as individual board members at this moment in time are just voting to issue yes or no that you want this notice of charges to go out. It's under our current statutory scheme, Dr. Safran and Dr. Rothermel who get to make the determination on the immediacy.
Okay, so wait a second. So fiduciarily, we're voting. I mean, really and truly, we're not voting on anything here because we would never say not to vote for a site to go out. But you're asking us to reaffirm the decision the supervising member and secretary has made statutorily without any information except a very cursory charge. So I think fiduciarily a court would hold us responsible if a perpetrator goes on to assault 5 more patients from here between now and the time of adjudication. If there was that clear and convincing evidence, I think they would hold the whole medical board liable. I'm not a lawyer, but that would be my thought on this. So we are making a vote to agree with this course of action, I think. Am I wrong about that, Kim?
We are making a voting. Right.
You're voting on the charges. We need a majority of the board to vote to bring charges. And that's what you're voting on. I think you've been really clear, though, in providing information for enforcement and the AG's office and the secretary and supervising member about the types of things that you're looking for when, you know, there are cases where, you know, the evidence doesn't maybe meet the summary suspension, but it looks like a really egregious case, and that you want some more information on that. And, you know, so I think you've been really clear about your concerns there. What's in front of you right now is to vote on the notice of opportunity to bring charges and give the individual an opportunity to ask for a hearing. And we need a majority of the vote of the board for that.
Kim, I think it's just a question of the severity of whether you do a summary or a citation. And I guess I'm going to ask Kyle in a generic way, not on this specific case, in a generic way. When you're confronted with a case where behavior is really troubling, but your evidence doesn't appear to reach that threshold that you need for a summary, do you, as the Attorney General, or do you, Rebecca, step in to try to negotiate, to take the light, to say, to do something to ensure that they're not, to see if there's any negotiation to keep this person from practicing while this thing goes on?
You mean negotiate with the target of the investigation or their counsel?
Yes, generically speaking, where you don't, so you never do that. And Rebecca, you?
Well, if we could settle something with them, we'd be bringing you a settlement. In most of these cases, we're charging them because people are denying the allegations.
You know, it's not a lot of, sorry, Mr. Jacome, go ahead.
And that's just one follow-up question. This is to both Kyle and Rebecca. And help me to understand, because maybe I don't get this. Let's say we as a group say, no, we wanted a summary. It goes back, you issue it as a summary, even though you disagree. And I understand that. And what happens if we lose? Okay, so we lose the summary. If we still have a notice, don't we? We still bring them in. There's no difference. Is there, or am I missing something? Was if we get challenged on the summary, that this person walks and everything gets cleared?
You can't issue a summary. You can't issue a summary suspension unless the secretary and supervising member of the board believe that those two prongs are met.
Okay, but let's assume they do that. Let's say we say no, they go back, they have a change of heart. It's possible. They come back, they issue the summary. Okay, so we go with the summary. You guys think, you know, it's a loser, got it. So we go to court and he challenges us, right? So then what happens? That's what I'm asking. Okay, what is the path forward? Does that mean is the dismissal of all the charges in the notice, or he just doesn't get we don't get the pleasure of summarily suspending him?
Yeah, so I think the real answer to this is the reason you're always balancing the summary suspension and being careful is the legislature has given us that as a power with for very severe circumstances where you do have that higher threshold of clear and convincing. The real risk of doing a summary suspension when you don't have a clear showing on those prongs is not the individual case. It's the fact that you will get bad case law that then limits or takes away your ability to do summary suspensions that will hurt you down the road on cases where you're really going to want that you had it. So it's kind of like a nuclear bomb. It's a really, really powerful weapon, and we're glad we have it, but you just can't like wipe out the earth with it or they'll take it away from you. It's that kind of balance we're always talking about with our AGs and looking at on a case-by-case basis and trying to figure out where the line is for different things.
So you're concerned about the political ramifications of overusing the summary suspension?
I'm always concerned about being correct and being fair to every case we're looking at. using our process in our current statutory scheme, making sure we're following the law and looking at those practical implications of, what will happen to us if we overreach. We just saw that in the case, that got overturned recently on the exam issue. We were aggressive on that in what reasonable minds thought was a good basis, and the board said, we don't disagree, and we got a big smackdown. That's going to be a much, much bigger problem for us if it happens in summary suspension world. So it is complicated. I don't want you to think that the secretary and supervising member are not aggressive or don't take your feedback seriously. We are always just doing the best job we can do on every case. I agree with Kim. We've heard your feedback. What I'd really like right now today is to at least get this guy charged.
Yes, I think I heard Stane. I'm just not sure. It's look, this isn't a referendum on Bruce and Kim. Number one. Number two, I think what I'm hearing you say is you still can tag them if you lose a summary suspension. You just prefer not to do that because you're concerned this legislature is going to view us as overly aggressive and take away that stick that we got. I think that's what I'm hearing. I feel like I get jarbled up in a lot of other stuff that isn't the question, but I think that's the three takeaways, right?
I think what I'm trying to say is we should not be summarily suspending people unless the secretary and supervising member feel in their responsibility and authority that is legally and morally and evidentially correct. And that's not what they've brought for you this time. I mean, I don't have a summary suspension for you. I have a cite for you. In theory, you could, reject a cite, which Dr. Fievel, you mentioned the board actually has not issued a couple of cites in all the years I've been here, but just a couple. But if the secretary and supervising members still feel that it doesn't meet the burden of summary suspension, you're just going to get the cite back again. I mean, that's just the statutory scheme we have.
In fairness, the secretary and the supervising member, you've advised them, and Kyle's advised them. They're not lawyers.
Correct.
And so it's not really fair to say that it's just their decision because, quite frankly, I would suspect that Bruce and Kim would be most respectful of the recommendations that come from the lawyering side. So in fairness, there is a little bootstrap on your part, on your argument. Also in fairness, these sex cases are very difficult because the complainants oftentimes do not want to get engaged, do not want to be part of any process, whether it's criminal or civil. And so, or you have trouble finding them. So in fairness, there are some evidentiary issues we don't know that, but in fairness, it's not just Kim and Bruce that are making these decisions. It's really the lawyers are have a great influence in making a recommendation. So I'm not comfortable with this. I will vote for the site, but I do think at some point we may have to expand our process a bit.
So this is by no means the first conversation like this that we have had, where we've had a citation come our way that was not a summary suspension, but that looks like, to our eye, should have been a summary suspension. And I guess I'm wondering, because I very much appreciate your, concerns. I wonder if there's a way to set these cases aside to be examined after the fact. In other words, as like a quality assurance method, if we could have, let's say, another board member or two, when this has been litigated and processed and it's sort of behind us, if then we can have, another board member or two, maybe along with secretary and supervising member and staff, just have another set of eyes on it, either to confirm that, yeah, we went down the right road, or to say, maybe we should have done this a little differently. Is that a possibility for us?
Yeah, I
think that's a good idea. I have one other question in that regard. Can these cases that we're very concerned about be fast-tracked? I know there's certain statutory limitations, but we should not be the rate-limiting step in these. For this to come from the site to an R&R, it should be very rapid and as rapid as is allowed by law. These should go to the top of the pile and be adjudicated quickly. There's certainly no harm in that.
So I'm not in charge of that. I don't have control over the hearing unit. I assume that the executive director could communicate that to the hearing unit. But I appropriately do not interface with the hearing unit since I'm not supposed to. But I understand what you're saying.
I have one other suggestion. I don't know, this is probably going to be very out of step, but here it goes. We don't get these that often, right? I mean, we don't usually, I mean, it's not like it's a daily occurrence, right? We get this struggle with, is this a summary suspension or is it not? I would say, what if we do this? Kim and Bruce, when you get these, and I'm talking about all of you, okay? And it's something that you think is going to gear up the group in terms of, we're going to have this discussion ad nauseum. I say you pull one of the board member who isn't the secretary or supervisor into the discussion. They have to recuse themselves for the event, but at least you have a third person in there, and maybe it's, one of the attorneys, God forbid, put in there. At least that way it might give some comfort to the rest of the group. Okay, it wasn't just, Kim and Bruce who are not attorneys, but maybe there's somebody else in there that's a little bit more difficult to deal with, whatever you want to call it. And then maybe you have some comfort with the outcome. But realizing that person who steps up is going to be recused because they can't be part of the process of decision making. I'll throw it out there. I don't know if that's a solution, if that's something we want to consider, but it might help to alleviate some of this stuff and start to maybe set a trend as to which way we're going with this. Thoughts?
The only thing I would say is, I think if you do that, you'd have to change your statute. I think you'd have to make a statutory change.
Why?
Well, now the statute sets who makes the determination on that evidence. You've got something that's kind of similar with respect to settlement agreements. When settlement agreements go below the disciplinary guidelines, we do pull in the board president. That's via a rule. So there's a rule that sets that. But because and this is just off the top of my head, and we can certainly do more research on it. But because the statute in 473122G, I believe, sets who makes that determination, I think if you were going to change that process, I think you would have to make a change. And that's just off the top of my head, and I'm certainly willing to explore it. But that's just my thought.
Yeah, the third party isn't making the determination. They're just reviewing the information, and then Kim and Mark still make the decision. They just report back that the third party agreed or disagreed. That person has no voting right. It's more an observer and someone who provides input into the process. That's it. There's no decision.
Yeah, and apparently we used to have a post-mortem process several years ago. Anita Steinberg was telling me about it, and so it may be something that perhaps we should look at a retreat. Because again, not taking anything away from our two hardworking youth members, but apparently we used to have some kind of a postmortem. And as we do a postmortem on some of the sticky cases that have gone through, and we want to make sure we'll have a better sense of what's being viewed, how things are being viewed, and how things are being presented, and the process itself. But just a suggestion.
What I'm proposing isn't a post-mortem. I'm talking about real time.
Yeah, I was proposing a post-mortem.
Yeah, no, I'm talking about real time.
Yeah, I appreciate the desire to do this in real time, but that's sort of what I was getting at a little bit ago when I said, is there a way to sort of reserve these sticky cases, so that they can be assessed, another board member or two, to take a look at this, because at least it would give us some consolation, hopefully, that from a quality assurance standpoint, we're making good choices along the way, or are we starting to find a fact pattern that causes us concern where we need to address things additionally?
That's probably doable if, without a statutory change, as a consultation without a vote. I mean, the consultation with the board member would of course disqualify on the final vote, but it could be a consultation, but the final vote is with the, always remains with the two statutory members that are statutorily responsible. That I think that might work.
Well, here's the
I'm
only
throwing
thing.
it out there. I'm not married to this. I'm just, we seem to keep revisiting this, and I'm throwing out, is this an option that consider? If not, you're not going to hurt my feelings. I'm just throwing it out there.
The only thing I would say is that the likelihood is in a situation like this, we would want to have the board member whose expertise was most relevant to the case probably take a look, right, in a situation like this to weigh in with the secretary supervising member. But then on the back end, we lose that expertise when it finally comes to the board. So it's a trade-off. Okay, any other discussion regarding this citation?
So what do we decided in the end? What are we going to do? Post-mortem? We're just going to look at the, I don't, we have these discussions and we just kind of, it just hangs there.
I think let's see what the FSMB audit comes back with, because that was substantially their job, was to sort of weigh in on our processes. Maybe let's start there. But I don't see anything that gets in the way of a post-mortem, right? What we're calling a post-mortem, to have some quality assurance into the mix, where that would give us not necessarily, immediate gratification in situations like this, but at least knowing down the road that we're sort of keeping an eye on these concerning cases and not just letting them fall through the cracks completely. Hi, Stephanie.
Hi, I would say too, in the meantime, while we wait for the FSMB report, we can do some research and pull some options together as well. So we're not waiting for the report and then waiting to so that we're not dragging this out. So we will get to work on the feedback. I've been taking notes as you're talking, and Kim and Rebecca and I can debrief after and come up with some options as well.
Great. Thanks very kindly. Any other discussion regarding this citation?
Okay.
Sorry.
Next.
We're good? Okay. Okay. Rebecca, would you be so kind as to proceed then?
Yes, citation number 6 is to be issued to an MD. This is based on a plea of guilty for unlawful dispensing of Schedule II controlled substances, and not an immediate because this Ohio license is lapsed. Citation number 7 is to be issued to an MD. It's based on action taken by the Pennsylvania board related primarily to infection control. And last but not least, citation number 8 to be issued to a DO. This is based on failure to cooperate in our investigation, trying to get CME information. Thank you.
Thank you so much, Rebecca. Is there any further discussion? Okay. Do I hear a motion, please, to, forgive me. We will be considering citation numbers 7 and 8 separately, so Dr. Bechdel may abstain or vote appropriately. Would any other board member like to consider a citation separately? Okay. Do I hear a motion to approve and issue citations 1 through 6?
Dr. Bechdel, so moved.
Thank you. And a second?
Second, Dr. Carolla.
Thank you so much. Roll call, please. Dr. Rothermel?
Abstain.
Dr. Seraphin?
Abstain.
Mr. Jiggle?
Yes.
Dr. Stane?
Yeah.
Dr. Johnson?
Yes.
Dr. Carolla?
Yes.
Mr. Gonococcus?
Yes.
Ms. Montgomery?
Yes.
Dr. Fievel?
Yes.
Dr. Bechdel?
Yes.
And myself, Michael Schottenstein, yes. Do I hear a motion to approve and issue citations 7 and 8?
So moved, Dr. Carolla.
Thank you. And
Second, Dr. Johnson.
thank you so much. Roll call, please. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Jackalone?
Yes.
Dr. Sohn?
Yeah.
Dr. Johnson?
Yes.
Dr. Carolla?
Yes.
Mr. Gonococcus,
Yes.
Ms. Montgomery,
Yes.
Dr. Fievel,
Yes.
Dr. Bechdel,
Stane.
and myself, Michael Schottenstein, yes. As you are aware, the end of Dr. Edgin's term as a board member resulted in a vacancy in the office of board vice president.
I think.
Mark, this is the only
Please
You-
pause for 1 minute. Can you please pause the board meeting for 1 minute? We just lost the live stream for a second. It needs to buffer, okay?
Of course.
So please hold on for just 1 minute.
Dr. Schottenstein, while you're pausing, thanks to Bruce and Kim for putting up with us in that long conversation. It must be so frustrating to you. Thank you.
I completely agree. Thank you.
All right, the live stream is back to full health. Thank you. You may proceed.
Thank you so much. We'll move on to operations report. Ms. Stephanie Luca, Executive Director, will now present the operations report, please.
Okay, thank you very much. I'm just walking through the operations report with you. You'll note that our HR status has not changed greatly, and we are, still figuring budget situations out as well as hiring freeze. So not much movement on any positions right now. For finance, I know Dr. Schottenstein will talk about the numbers in great detail in the finance committee report out. I do just want to point out, and as he will talk about as well, that our renewals are definitely down due to the license renewal extension that was granted by the legislature in light of the pandemic, and we are about 50% down in our renewal fees and about 50% down in our renewals on where we should be with this. We've identified those licensees who have not yet renewed, who are taking advantage of that extension and for whatever reason. And we're going to start a communication strategy, just reminding people, maybe now that practices are back open, maybe now that office managers are back to work in those practices, or, things have slowed down a little bit. We are going to send a reminder out that they can renew. And so hopefully generate a little bit of renewal from them through a communication strategy. Otherwise, they have until December 1st or 90 days after the end of the state of emergency, whichever is first. This month included some numbers for you from the OPHP, which is the One Bite program. This was a request at the last board meeting. I think Ms. Montgomery asked how the program was going, and Dr. Schottenstein followed with a question as to our B19 participants as well. So the numbers for you are, it's a 1 quarter snapshot in time. I think we really need to trend these numbers over probably the next couple of quarters to see how we're doing with the implementation of the program. We've had some really good conversations with OPHP as we've implemented, and I think that those will continue, and we're sort of learning from each other. We know that there have been some concerns about providing information to them about licensees, and we all share the same common goal of wanting to make sure that licensees can avail themselves of this program and participate in it and be successful in it. So we're working collaboratively to try to make that happen for our licensees. Some of those things may require statutory changes, some may be contract changes, some may be policy discussions. So we're staying in contact with them about those issues. So the numbers, those are, as I said, those are the quarterly numbers. They don't really tell us a lot because to the running of the program that, we need to see those numbers trending. Any questions on that? With respect to the B19 program, we have about 6 licensees who have availed themselves of that, and according to staff, everything is going smoothly with those participants. We have 2 who are near graduation from the program, and so I think that the fact that we do have participation and that staff is learning how to operate it best, and again, I think we're continuing to learn as we go from that program. Any questions on that? Okay, let's see, investigations. You have a report there from the investigations unit. I did want to also point out that our investigators and some of our enforcement attorneys are participating in a 3-day prescribing course that is being hosted by Case Western Reserve University. This is typically an in-person training opportunity. However, Case Western has created an online opportunity given the pandemic, and they very graciously offered us a discounted rate to be able to attend that. And so we, I think we've already heard reports back from staff that it's going very well and that they are learning a lot about the latest and greatest in the world of prescribing. Licensure, you will see that our issuance of clean licenses continues to, the time frame continues to decrease, which is fantastic. We are still pandemically related, having some challenges with background checks. A lot of local offices just haven't been open, and as those offices slowly start to open, our background checks will start to come in faster. But that has been a bit of a delay with respect to license issuances. There are numbers in there about our complaints. And again, as we talked about earlier, I think our real work ahead of us as we work from the FSMB audit, as we hear feedback from board members, and as we have staff discussions, we'll be tackling our open complaints load and making sure that we're using the right way, that we are being expeditious about the way we're handling all of the different stages of a complaint, but that we're also balancing that efficiency with outcome and ensuring that we're hitting that right balance, that we're not rushing things inappropriately, but that we are giving things the immediacy that they are due. And our communications department has a lot of great updates in there with stats. Obviously, our viewership continues to increase, particularly as we have more online meetings. And also just to highlight some of the work they've been doing lately, they put together some really great materials for the FSMB virtual hall of posters. So FSMB normally does this at their annual meeting, and they will be sending out these posters virtually for everyone. I had the chance to look at ours this past week, and the communications team did a fantastic job. They're highlighting recovery, our work with Recovery Ohio, as well as our work so far on the duty to report, both of which obviously highly relevant topics. And the last thing I'll point out to you in your operations packet, we presented to the Senate Transportation and Workforce Committee last week as part of the annual license review process. I think it's every 6 years. We were called relatively quickly to testify on that as Senate was pulling those committees together. And we had previously testified with the House on the exact same matter with the exact same questionnaire. So we updated that material, just as very basic updates to some of that material, and provided very similar testimony to the Senate, and received similar questions from the Senate about some of our more obscure license types. But I think the testimony went well, and no red flags or concerns that we had about our licenses that we need to discuss further. Great, I'm happy to answer any questions if anyone has any. Okay. Thank you.
Thanks so much, Stephanie. Next, Ms. Reardon will give the Dietetics Advisory Council report, please.
Thank you, Dr. Schottenstein. The Dietetics Advisory Council was held on June 8th, 2020 virtually. The council welcomed a new member, Kathy Shalito, and the reappointment of David Ryerson and Carmen Clutter to the council. A legislative update was given regarding pertinent legislation being heard by the General Assembly. We also discussed the board's action to assist licensees during the pandemic. And to Stephanie's point, we did mention that people should continue to renew their licenses and continue with their continuing education during the pandemic. There was an update from the Academy of Nutrition and Dietetics. and the next meeting is scheduled for August 11th of this year.
Okay, thank you so kindly. Next, Dr. Carolla will give the Respiratory Care Advisory Council report.
Thank you, Dr. Schottenstein. We met yesterday virtually. It was a brief meeting. I think there was an introduction of new members. I think a couple of things that we always do, no new data, but we always are keeping track of certification rates, graduation rates, and kind of what the respiratory care therapy schools are doing in terms of enrollment, dropout, et cetera. There's for licensure, there's consideration for ensuring that there's not licensure issues with the pandemic and that renewals had been extended. We have a meeting again, I believe it's September 10th. I don't know what the exact date, but it is in September. That concludes the report from yesterday.
Okay, thank you very much, Dr. Carolla. So next is the Sexual Misconduct Committee report, and I'll review that. This is from this morning's meeting earlier today. So we heard that 67% of the historical case review has been completed. There are only 400 cases left to be assigned out of the original 1,256. We're averaging 43 cases a week, and that's about 3 to 4% of the caseload on a weekly basis. That puts us on pace to have finished up this initial review by the end of September. So we've been invoiced over $100,000 relating to this matter. The Assistant Attorney Generals have been contributing to the effort as well, and that has provided us with $9,000 in cost savings. Thank you. We've used 2,770 hours of staff time on the historical case review thus far. We received an update on the review of cases. Every matter is being investigated. Everything has been documented thoroughly. After the outside review, there's a quality assurance check. The Secretary and Supervising Member weigh in. Enforcement and Investigations weigh in. Our Executive Director weighs in. Over 200 of these cases have been reviewed thus far. We've been mindful to be very careful in consultation with victim advocates that when we recontact the witnesses in these cases, that we do not re-victimize them. So we are generally sending a letter as an initial step to let them know that we're looking into the matter again, to give them time to process that. We continue to reprioritize cases as well, depending upon what we learn as we go forward. But the most egregious cases generally are looked at first. We also had an update about the FSMB audit. That's wrapping up and included interviews with multiple board members and staff. Ms. Luke is pleased that it appears that the FSMB has a good understanding of our processes. We hope that the audit will be completed by the end of this month, and then we may review the matter further together at the July meeting. That concludes my report on sexual misconduct. So, Dr. Soin, if you'd be so kind as to present Policy Committee.
Yes, I'm happy to do that. Thank you. So Policy Committee met this morning, and we went over a rather robust legislative update after we did a brief update on the rule spreadsheet and schedule. A couple of just take-homes from the legislative update. One is we're going to do a better job of articulating the medical board's official stance on various bills that have direct impact to our licensees and to our citizens of Ohio that we think are important. So we'll probably see some more aggressive opinions and stances that are articulated in the Policy Committee meeting for others to see. Additionally, we spent a lot of time discussing telehealth. The medical board and the Policy Committee members realize that this is a very important initiative for our citizens and our licensees, and we want to make sure we get this right in terms of feedback that we can provide as the General Assembly looks at adopting some form of legislation around the area. As a result, we're going to have members of the medical board who have volunteered their time to do one-on-one questions with staff members on the board who may have them. And it's possible, although not a guarantee, but if we have a group meeting that requires a public meeting, we will announce that, have a public meeting on the matter prior to the next policy committee meeting. Although that's not necessarily guaranteed, it is a potential opportunity if we see we need that. Additionally, we discussed microneedling as a introduction to a broader topic that we'll be discussing next month. We updated the death certificate position statement, and we updated the weight loss frequently asked questions amendment to remove Belviq, which was pulled from the market. We also moved to file some rules with CSI and some CSI updates and rules for initial circulation. And on that note, Kim, is there items or action items that the medical board needs to discuss as a whole at this time?
Typically, we would take a vote on the radiologist assistant rules, the personal information personal information system rules, and the dietetics rules to file with CSI. I also wanted to give just a quick update on some legislation. I think we will send information out to board members and policy committee members, but just in reflecting Senate Bill 308 and House Bill 606, which provides immunity to healthcare workers who provided care during the emergency, is a bill that we need to be watching. Some of that immunity could expand into professional discipline as well. And so we'll provide you more information on that, but that was something that after policy committee, we thought you might not have had that information. And those bills are moving. So we'll provide more detailed information, but I did just want to give a quick update on that. And then I think if we could have a board vote on the rules to file with CSI, which is the radiologist assistant rules, personal information system, and 2 dietetics rules.
Is there a motion to file with CSI?
So moved. Dr. Bechdel, so moved.
And we'll take a voice vote. All in favor, say aye.
Aye.
Any opposed? Thank you. I think that carries. And unless Kim has anything else, that concludes my report.
All right. Thanks so much.
Thank you so much, Dr. Sohn and Kim as well. Thank you. Next is Finance Committee update. I'll present that. So looking at our fiscal update for April 2020, revenue was $632,619. That is less than half of the revenue that we accrued for the month of March. So regrettably, that is quite low. It's also 52% less than it was 2 years ago. Looking ahead to the May numbers, they are just about as bad. And worse yet, the last quarter of the fiscal year, April, May, and June, are typically our biggest months of revenue. The good news is that we know why the revenue has dropped off. As we heard earlier, you may recall that due to the COVID-19 pandemic, license renewal date deadlines were delayed, either until 90 days after the emergency orders lifted or until December 1st. We had originally projected revenue of $11.2 million for fiscal year 2020. Now it's looking more like we will have revenue of approximately $10.2 million. We will eventually get the revenue, but fiscal year 2020 is going to look artificially low. And then fiscal year 2021 will look artificially high because of the deadline extension into 2021. So it's disconcerting at the moment. Again, we should get the revenue eventually, and things should even out over time. You can actually track the license renewals over the final quarter with regard to expected revenue. Typically, we have 13,000 license renewals in the final quarter of the fiscal year. We've had only 7,300 thus far, 55% of normal. So as we heard earlier, we're strategizing as to messaging licensees about encouraging earlier renewal and not waiting till the deadline. Unfortunately as well, April was a higher spending month. There are 2 reasons for this. We are billed quarterly for our rent, and DAS just sent us a bill. There was also a delay getting us the invoice for the bank fees that we owe from October through February, and we just received that bill as well. Having said that, you may see on the fiscal summary page that we still have over $1 million in net revenue for fiscal year 2020 year to date. Even numbered fiscal years are big revenue years for us traditionally. Our cash balance is approximately $5.5 million, which is down from about $5.8 million last month. You may notice on the fiscal summary page under historical case review that we have $78,283 remaining that is encumbered. That will likely spend down to about a $40,000 balance by the end of the fiscal year. That may potentially get us through the remaining case review project. You may also notice that on the fiscal summary page under allotments, we have a total allotment of $10,587,390. That is actually down from approximately $10.8 million. You may recall that there was a cut in our allotment that we were asked to make because of the budgetary environment. Having said that, for 2021, our appropriation is unchanged at $11.3 million, but that's for now. That took into account wage increases that may not materialize, so that number may change. Usually, we turn in our allotment to the Office of Budget and Management annually, but because of the budgetary environment, the OBM has asked for the allotment to be estimated quarterly. So we are sending in all 4 quarters of estimated allotment by next week so that OBM can have an idea as to when our spending will occur. We have not been contacted with regard to cuts thus far. I don't know if Susan's with us, if she wanted to add anything to that. So that said, exempt employees have been asked to take pay cuts in the form of 10 days off without pay. The bargaining unit is in negotiations as well. Any questions about the fiscal summary before I move on? Okay, thank you. You may notice on the page outlining our fines that we have collected no CME non-disciplinary fines for April. That is a function of our vote to delay enforcement on CME infractions. You also may see that there's a motion for us today. You may recognize it because we've had similar motions every year. It's to allow for the dedication of IT time by DAS to prioritize our projects. We are asking for an authorization of up to $49,500 this year, which is, I think, the same as last year. Last year, we used $18,000 or $19,000 of that, so we don't expect to approach that limit. So that $49,500 is substantially for e-license enhancements and to improve efficiency. That is in addition to the $80,000 that we're being charged by DAS for IT support. That number has gone up substantially from $30,000 the year before. So I'm going to go ahead and read the motion, if I may. The State Medical Board has for the past several years purchased additional Salesforce development hours from DAS OIT. The board utilizes these hours to implement system improvements as we further streamline and integrate our processes. Here are some examples of developments completed from fiscal year 20. The FCVS integration was updated to only allow profiles completed within the last 12 months to be transmitted to the board, ensuring we only get current data from applicants. Additionally, several system changes were required with the passing of House Bill 166, including the conversion of telemedicine to full licenses, adding a late renewal period for training certificates, and converting all licenses to a rolling 2-year expiration cycle. These changes allow for increased operational efficiency when processing renewals, as well as smoothing out revenue intake over time. Examples of projects for fiscal year 21 include enhancements to enable the board to automate and improve the subpoena authorization process, incorporate expert tracking and approval into the system, name change process automation, and a full system role profile overhaul. The rate per hour is approximately $113, and the staff is requesting that the board approve up to $49,500 for fiscal year 2021, with an estimated approximately 435 hours of development. So may I have a motion, please, to approve the purchase of additional Salesforce development hours from DAS OIT of up to $49,500 for fiscal year 2021 to support system enhancements?
So moved.
Dr. Seraphin, thank you. Is there a second?
Second, Dr. Carolla.
Dr. Carolla, thank you so much. Is there discussion? Okay, we'll have a vote then, please. Do we need a roll call on that? Sorry, should we take a roll call vote?
Roll call. Yeah,
Okay,
I don't, yeah.
Vote then, all in favor, aye?
Aye.
All opposed? Okay, thank you very much. That concludes my Finance Committee report. And next on the agenda is Dr. Seraphin. Thank you.
Thank you very much, Dr. Schottenstein. First is Ma'am Ajak Fu has applied for an Ohio respiratory care professional license in Ohio. She has not practiced clinically since March of 1999. Do I hear a motion to approve her application for an Ohio license contingent on successful completion of the clinical simulation examination within 12 months of the date of mailing of the notice of opportunity for a hearing?
So moved. Second.
Do you want to do the roll call, Dr. Schottenstein, or do you want me?
Well, it's my pleasure. We'll take a roll call, please. Dr. Rothermel?
Yes.
Dr. Saffron?
Yes.
Mr. Jiggle?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Carolla?
Yes.
Mr. Gonococcus? Mr. Gonococcus? Ms. Montgomery? Ms. Montgomery? Okay. Dr. Fievel?
Yes.
Dr. Bechdel?
Yes.
And myself, Michael Schottenstein, yes.
Next is Dr. Wang has applied for a medical license in Ohio. She has less than 24 months of postgraduate training in the United States, but requesting that her training in Australia combined with the 12 months of acceptable training she has received in the United States be deemed equivalent to 24 months of graduate medical education through the second year level of graduate education. Do I hear a motion to grant the graduate medical education equivalence as outlined in 4731.09A4B so that Dr. Wang may be granted a license?
So moved.
Dr. Rothermel, and
Second, Dr. Johnson.
thank you so much. Further discussion? Roll call, please. Dr. Rothermel?
Yes.
Dr. Saffron?
Yes.
Mr. Jiggle?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Carolla?
Yes.
Mr. Gonococcus? Mr. Gonococcus?
Yes.
Ms. Montgomery? Dr. Fievel?
Yes.
Dr. Bechdel?
Yes.
And myself, Michael Schottenstein, yes.
Next is Sandra Ramakhan. She has applied for a restoration of her Ohio license to practice dietetics. Considering that that Ms. Ramakhan dietetic registration with the Commission on Dietetic Registration is current, staff recommends that her license be restored. The motion is to approve her application for restoration of her Ohio license as presented.
Motion?
So moved.
Dr. Bechdel, thank you. Discussion? Roll call, please. Dr. Rothermel?
Yes.
Dr. Saffron?
Yes.
Mr. Jiggle?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Carolla?
Yes.
Mr. Gonococcus?
Yes.
Ms. Montgomery? Dr. Fievel?
Yes.
Dr. Bechdel?
Yes.
And myself, Michael Schottenstein, yes.
Next is Hassan Askari, MD. Dr. Askari has applied for a medical license and has requested a waiver of the USMLE 10-year rule. Dr. Askari's specialty board certification is currently active, and he is participating in maintenance of certification. Do I hear a motion to approve the good cause exemption to the 10-year rule as outlined in OAC 4731-605C1 and accept the examination sequence so that Dr. Askari may be granted a license?
Motion?
So moved. Dr.
Dr.
Johnson.
Rothermel, thanks. Dr. Johnson, thanks. Discussion? Roll call, please. Dr. Rothermel?
Yes.
Dr. Saffron?
Yes.
Mr. Jiggle?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Carolla?
Yes.
Mr. Gonococcus?
Yes.
Dr. Fievel,
Yes.
Dr. Bechdel,
Yes.
myself, Michael Schottenstein, yes.
Next is Lanny Daly, has applied for restoration of her Ohio Respiratory Care Professional RCP license. She passed her RRT exam in March of 2020 and holds current RRT registration. Because she has recently gained her RRT registration, licensure staff recommends approval of her restoration application. Do I hear a motion to approve her application for restoration of her Ohio license as presented?
Motion?
So moved, Dr. Bechdel.
Thank you.
Second.
Dr. Rothermel, thanks so much. Discussion? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Jiggle,
Yes.
Dr. Sohn,
Yeah.
Dr. Johnson,
Yes.
Dr. Carolla,
Yes.
Mr. Gonococcus,
Yes.
Ms. Montgomery.
Yes. Yes.
Dr. Bechdel,
Yes.
and myself, Michael Schottenstein, yes.
Next is Mohammed Kamil, MD. He has applied for a medical license in Ohio. He has less than 24 months of postgraduate training in the United States, but is requesting that his experience and training in Egypt and Ireland, combined with the 10+ months of acceptable training he has received in the United States, and his 11 years of practice experience in the United States, be deemed equivalent to 24 months of graduate medical education through the second-year level of graduate medical education. Do I hear a motion to grant the graduate medical education equivalents as outlined in 4731.09A4B so that Dr. Kamil may be granted a license?
Motion, please.
So moved.
Dr. Rothermel and
Second.
Dr. Bechdel, thanks so much. Discussion?
I had a question about this case for Dr. Safran. I'm a little confused by it. His practice experience, he's licensed in another state currently then?
I believe he is, yes.
Okay. I'm not sure how he got licensed in the other state, given such small amount of training, but I mean, if he's been practicing for over a decade without issues in another state, it's hard to argue against those results.
And he was thoroughly vetted, obviously, for any complaints.
Yeah, it's just surprising. Okay, thank you.
Not every state is like Ohio.
Thanks very much. Further discussion? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Jiggle,
Yes.
Dr. Sohn,
Yeah.
Dr. Johnson,
Yes.
Dr. Carolla,
Yes.
Mr. Gonococcus,
Yes.
Ms. Montgomery,
Yes.
Dr. Fievel,
Yes.
Dr. Bechdel,
Yes.
and myself, Michael Schottenstein, yes.
And last, a name that I can actually say is Nicholas Smith, MD. Dr. Smith has applied for a medical license. He has less than 24 months of postgraduate training in the United States, but is requesting that his experience and training in Australia, combined with the 12 months of acceptable training he has received in the United States, be deemed equivalent to 24 months of graduate medical education through the second-year level of graduate medical education. Do I hear a motion to grant the graduate medical education equivalents as outlined in 4731.09A4B so that Dr. Smith may be granted a license?
So moved, Dr. Carolla.
Thank you. Second? Dr. Bechdel, thank you. Discussion? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Jiggle,
Yes.
Dr. Sohn,
Yeah.
Dr. Johnson,
Yes.
Dr. Carolla,
Yes.
Mr. Gonococcus,
Yes.
Ms. Montgomery,
Yes.
Dr. Bechdel,
Yes.
and myself, Michael Schottenstein, yes.
Dr. Schottenstein, this completes the report of the licensure committee.
Thank you so much, Dr. Safran. Next, Dr. Bechdel will present an update from the Medical Marijuana Expert Review Committee, please.
The committee will review the export report at our 3 o'clock meeting today, committee meeting, on the petition to add cachexia to the list of conditions that can be treated with medical marijuana. The committee will then make recommendations to the full board on whether to approve or reject the petition. We expect the board to be able to vote on the petition at its July 8th, 2020 meeting. However, to account for any unexpected circumstances, I'll ask the board to extend the window for issuing a decision on the petition by 90 days. The board will also render decisions on petitions regarding anxiety and autism. Do I hear a motion to extend the deadline to issue decisions on the petitions to add cachexia, anxiety, and autism spectrum disorders to the list of qualifying conditions for the treatment with medical marijuana to September 28, 2020, pursuant to 4731-32-05 of the Ohio Administrative Code, so that the board may review the expert report prior to rendering a decision.
So moved.
Dr. Safran and
Second, Dr. Carolla.
Dr. Carolla, great. Further discussion? All in favor, voice vote? Aye.
Aye.
All opposed?
Abstain.
Thank you, Dr. Bechdel.
Thank you.
Next on the agenda, please turn to the compliance section. Do I hear a motion to approve the compliance staff's reported conferences for May 11th and 12th, 2020?
Move.
Motion, Mr. Jackalone and
Second, Dr. Johnson.
Dr. Johnson. Thank you so much. Any discussion? Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Do I need to abstain?
Probably. I don't know. I don't know.
I know there's on the report for conferences, just, okay.
I think yes. I think typically the secretary and supervising member do abstain on the compliance votes.
I'll change my vote to abstain, please.
I'll abstain.
Thank you. Mr. Jackalone?
Yes.
Dr. Sloan?
Yes.
Dr. Johnson?
Yes.
Dr. Carolla?
Yes.
Mr. Gonococcus?
Yes.
Ms. Montgomery? Dr. Fievel?
Yes.
Dr. Bechdel?
Stane.
And myself, Michael Schottenstein, yes. At this time, we will consider the probationary requests in today's agenda that have been prepared by the Standards Review and Compliance staff and distributed to board members. Before asking for a motion, does any board member wish to consider a probationary request separately? Do I hear a motion to approve the secretary and supervising members' recommendations for the probationary requests? Motion?
So moved, Dr. Carolla.
Thank you. And
Second, Dr. Johnson.
Dr. Johnson, thank you so much. Roll call, please. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Jackalone?
Yes.
Dr. Sloan?
Yes.
Dr. Johnson?
Yes.
Dr. Carolla?
Yes.
Mr. Gonococcus?
Yep.
Ms. Montgomery? Dr. Fievel?
Yes.
Dr. Bechdel?
Abstain.
And myself, Michael Schottenstein, yes. That concludes the June 10th, 2020 meeting of the State Medical Board of Ohio. Do I hear a motion to adjourn?
So moved.
Dr. Safran? Dr. Carolla, thank you so much. All in favor, voice vote, aye?
Aye.
Aye.
All opposed? All right. The time is 1:21 p.m. and the meeting is adjourned. Thank you so much, everybody.
Thank you.
Nice to
Thanks,
see you.
everybody.